Hi guys, it's Kathy. I hope you're doing well. So, I think we're going to the sentencing today. I'm not sure. I just don't know. Because October 2nd, so this is the next month. So, it looks like it, but it's actually they're short little videos. We're going to skip that first one. It's just our Nevada judges and credits and stuff. But it's so long. It goes into November, unless there's other charges, which is what I think. Because then it goes into January. So, and those are longer. So that looks like another trial. It looks like he's in a lot more trouble. And then at the very end, which is November 2020, it looks like we have three of his brother, and then one of him, two of him, and then we end with his brother. So, I don't know. Oh, happy Valentine's Day. Because you are all my Valentine. Because I love you guys every day. Every day. Oh, Snoopy's here. Okay, Snoopy, but did you try smiling? I mean, that's what I have to do. Just smile. I'm glad you're not in so much pain. But I hope you're not in so much pain just because of, the amount of drugs they give you when you get out of surgery. I'll be your Valentine, Bobby. I'll be everybody's Valentine. Because you're all my Valentine. Except for you, Michael McDonald. I don't want you to be my Valentine. Let's go.
McDonald, 335-284, Mr. Miller, with the defendant in custody. This is your motion, several motions.
Thank you, Your Honor. Before we proceed, I would once again object to the English being incorporated. The previous proceedings,
This camera, the organization represented itself to be a member of the press. It is in fact not. It is a political organization, basically controlled by Mr. Marshall Willett. He uses this to intimidate and exfoliate would-be attorneys, opponents, judges, and this video is
Fine. I'm everybody's Valentine except for Bobby and Fozzie.
appointed and presented to Overland Family Court organization called Nevada Court Watchers. I've had almost zero contact with Mr. Willett over the last 30 years of my career. When I spoke with him and had him on cross-examination, that would have been 10 times as much as I've spoken with him on the rest of my life. And as a result of criticizing Mr. Willett and his position of this court, I have been rewarded by Mr. Willett by having my divorce complaint put on Facebook posts somehow out of his office. I have been rewarded by unflattering pictures and some other fairly scurrilous, actually defamatory comments. Now, I don't care. I promise you, no one can easily dissuade me, as you're well aware. Having said that, I point that out not for complaint. I point that out as an example. I've had no contact with that man. Literally no contact with him. All I did was have his Mary rightfully
Her hair is down.
justly cross-examine him and question about his impartiality in the stand. And in return, I'm exfoliated on Facebook using that mechanism there. These people are scum. They are anathema to our legal proceedings. They use it to intimidate litigants, to criticize people they disapprove of. I object to this organization being in the courtroom and having their cameras here. And I'll proceed with my oral arguments on the rest of the points.
Well, let me at least comment on that. The definition of media has certainly expanded in the days or the years of the internet. And as you know, the Supreme Court has placed the burden, has made it a presumption of the media being present. It does, and certainly I acknowledge the sometimes one-sidedness, we're hit by arguments regarding fake news, but it is not up to the court.
Wait a second. Wait a second. The sometimes one-sidedness, the hit of fake news. We are showing the entire trial. We're showing every word. I know. I guess we can make shorts out of it and things like that, but this whole entire trial, every single word, both sides were shown exactly the same.
To make a determination as to what is quote-unquote legitimate media versus anything else. As you know, our courts are open to the public, and therefore
Where I have to dissent, respectfully, Judge, and I understand the court's reasoning, and at least going into proceedings, I could at least understand the court's position that they should be open to the public. And if this was an effort to do anything other than intimidate, accuse, and manipulate things to their advantage, this is not press. This is an equivalent of an Eastern European political organization. Now, that's what they are. And I've not never been on the court website. I did, however, attach a couple of the posts to them. There's not a person who believes in the rule of law who can be comfortable with this organization. I don't know how a legitimate member of the bar can be involved with these people. This is not the due process of law, the equal application of law to fact, equal justice before the bench. One of the people intimately involved in this organization is, in fact, and when it comes to this argument later, is in fact some of the persons who actually created the evidence in this case and the companion case down the hall. This is extraordinary, and I'm saying that in measured, unemotional terms. This is extraordinary in the history of the state. I've never, even back in the mob days, have seen anything like this. This is scurrilous behavior through and through. It's not defensible. It cannot be defended. You gave them a chance to show that they were a media organization. They have now shown you what they are. This is Mr. Willis' hate police, and I object to them being in this courtroom. And if you, I understand if you disagree or you're in a tight spot, I'm making a record here, Judge, for appellate review. This organization is bad and it needs to be moved out of the courtroom.
And as I started to say, the problem is how do we decide which organization is, if you will, fair and legitimate versus otherwise. And as I said, the Supreme Court places the burden, or it's open, the burden is to open the courtroom versus not. So I take your objection. Let's go to the motion.
Thank you, Your Honor.
Oh no, he was guilty to everything but one. I think today is the sentencing. Louis, you don't have to stand in line. You can pee on the line. Donald, it's a dog.
specifically, now that time has passed and a couple deep breaths have been allowed to be had, upon reviewing the record and the testimony, this should grant or set aside this conviction as based on insufficiency of the evidence of criminal intent. Now, this case would potentially going to set a very dangerous precedent. Family court, about 2/3 of litigants down there are unrepresented. Now, we criminalize paperwork. For the first time ever, it's not a civil infraction. And I want to understand the context here. There's insufficient grounds of criminal intent. Now, things get heated in court on occasion, I understand. But the judge who presided over these proceedings, she didn't take any action. She was one who saw everything. She was one who saw things in context. You're here every day. You see things get heated. Okay. You know where to draw the line, Judge. It's your courtroom. That's your decision. Now, one of the reasons we have the insufficient evidence here of criminal intent, we have a system of push and pull by three branches of government. The judicial branch, which applies the law to the facts, the judge presiding over these cases down in family court saw fit to send it over for criminal contempt. All right? It's the judiciary that runs the judiciary. It's a judge who runs the courtroom. You're the final arbiter of all that happens in here. Now, the judge who presided in this case didn't file criminal charges and did not refer this to criminal charges. Why? She didn't, inferentially, didn't see evidence of criminal intent. Sloppiness, maybe, but there's not any evidence of criminal intent. Now, we're taking and holding a person to the criminal standard on what in any other circumstances would be an administrative matter. Now, and I want to put this, and I want to overlap these two arguments a little bit. Now, I want you to understand, there was a criminal hearing set. The judge recused herself and set it for criminal contempt hearing in front of Judge Henderson. The state, in an unprecedented move, sought to intervene in a family court case. I've never heard of that. Perhaps the state will explain that, because no one has ever explained it to me. They go to intervene. Then the family court judge doesn't take any actions, literally sits, is still sitting there pending. Now the judiciary has surrendered to the executive branch what happens in a courtroom. That's extraordinary. It's just has absolutely no precedence in Nevada law. The district court judge will not. There's no, and the reason this wasn't filed as a criminal case, and it shouldn't be a criminal case, or was filed, the reason it didn't go forward in family court was there was no criminal intent across the board. We've got paperwork filed, we got a 6-month lapse from the time it's filed to the time the hearing is held, and then the supposition is brought before the bench. Well, look at this. 6 months ago he wasn't employed. Now he is. He must have been lying. Now, that's not criminal intent, and especially for a pro per litigant. Now, isn't the bar set awful high? I mean, at a certain point, would a pro per litigant even walk into family court? Now, this is of the 700,000 documents a year filed in family court. This is the only criminal prosecution I know of. Now, that goes through and laps right into another key point. Newly discovered evidence. There's an individual out there, Mr. Mark DeCero. I've never met him. I don't know much about him other than apparently he had been on a radio show. Mr. DeCero, for whatever reason, as you saw attached to my exhibit, when I kept questioning Detective Stanton. Well, Detective Stanton, you invested.
Who thinks this would go well better for Michael? He would get less time. He would have been charged with less crimes if this guy would stop it with this idiocy, and he would just say things like normal defendants. You know, I'm trying. I'm taking classes. I'm gonna do better. I know what I did was wrong. Take full responsibility. I start a new job on Monday.
Investigated him for filing for office, yes. And you concluded that he wasn't lying, he did in fact live there, yes. Then, when I asked the detective how he could have gotten a tip on Facebook, he says it was an anonymous tip. Well, you can't post anonymously on Facebook. It won't let you. Detective Stanton could not or would not say where he got the tip from. Well, Mr. DeCero removed all doubt. It was me. I did it. I put it all in on it. Well, that's interesting, and had I known that, That was very interesting news because Mr. DeCero was one who recorded and took the audio recording of Mr. McDonald's case, and that is the gravamen of the charge in the other file. Had I known Mr. DeCero was an operative, he had been on the witness stand and he'd had a lot of explaining to do as to why he, with no known ties to any of these people, decided to get involved, other than his involvement with Mr. Wilk. I've never seen anything like this. I am at a loss to even begin to explain it. Now, there's insufficient evidence. This case violates the separations of power. There's no criminal intent. Then we get to the more interesting arguments. Selective prosecution. Why? Why is Mr. McDonald singled out as the only guy in family court? Now, the state can answer how come or why Detective Stanton decided to file this charge alone, without request from the judge. And then if you have any meaningful doubt of what is in fact they are attempting to do here, read the comments on Nevada Court Watchers. This will teach Steve Sampson and his minions, Michael McDonald, not to screw with us, or words to that effect. I don't remember the exact posting. But that this was politically motivated is abundantly clear. And you can go ahead and read the comments. And if you think, and over the night of the postage, I complained bitterly during the trial. There was 26-something pages of those kind of comments. All of them that general ilk. Now, this appears to be the crime of pissing somebody off in family court. And that's all the long and the short of it. And I don't, nothing in my career in law in 30 years has prepared me for this case. I've never seen anything like it. I'm asking the court to vacate this conviction for the following grounds: insufficient evidence of criminal intent, vindictive prosecution, newly discovered evidence, and selective enforcement.
Thank you. Same.
Thank you, Your Honor. Okay, and first of all, though, defense counsel seems to be confusing the standard because the defense counsel filed, well, actually three motions: a motion for acquittal, a motion for new trial, and a discovery motion. But we didn't address the discovery motion today. Regarding his motion for acquittal, that motion can be made pursuant to NRS 175.31, which allows a court to enter a judgment for acquittal only when the evidence presented at trial is truly insufficient to sustain a conviction. This is an extreme sanction, and it's infrequently used, and for good reason, as it essentially negates the jury's decision, which is a vital component of our criminal justice system. Such a motion can only be granted when the evidence presented at trial falls below the minimum threshold for a conviction. So the question is whether, after reviewing the evidence in the light most favorable to the prosecution, any rational juror could have found the defendant guilty of the counts beyond a reasonable doubt. If any rational juror could have found the defendant guilty, then the motion for acquittal must be denied. And further, as the Nevada Supreme Court stated in Walker, it's the jury's functions, not the court's and not defense counsel's, to assess the weight of the evidence and determine the credibility of witnesses. Defense counsel is essentially asking this court to substitute his own credibility evaluation of the state's witnesses for that made by the jury, which is certainly not the legal standard. And I did not hear defense counsel cite a single legal tenet, case law, statute, or otherwise. And as to what the Nevada Supreme Court stated in Evans, the standard does not allow the district court to act as a 13th juror and reevaluate the evidence and credibility of witnesses. And defense counsel's motion provides no specificity as to how the evidence introduced at trial was allegedly insufficient for any of the charges. And I know Your Honor is obviously familiar with the evidence that was introduced at trial, but I just want to briefly point out this was a trial at which the jury watched a video of the defendant testifying in family court in which he testified under oath that he was unemployed and had no regular income other than odd jobs and at most made $800 per month. The jurors then observed the defendant's employment records for the time period in question, and which
Victoria went to visit him.
clearly showed that the defendant was employed as the assistant administrator or the go-to IT guy for the company at the time. And they heard testimony from Lisa Smith, the vice president of HR where the defendant worked, who testified that she saw him every day. He was their go-to IT guy, and she clearly testified that he was employed at the time of the offense. I don't know if I can't imagine a more clear case of perjury than that. So the argument that that's insufficient is quite frankly preposterous. And the only thing remotely specific that the defendant is saying was insufficient regarding, that defense counsel is saying was insufficient is intent. And, Your Honor, I think if this court were to grant a motion for acquittal on the grounds that insufficient evidence of intent was introduced, then this court would run afoul of the Nevada Supreme Court's holding in Rode, in which the court stated, and I quote, "State of mind need not be proved by positive or direct evidence, but may be inferred from conduct and the facts and circumstances disclosed by the evidence." And the facts in Rode were actually somewhat similar to this case. The defendant in that case was working as a marshal, and his job was to serve arrest warrants, and he signed a number of documents indicating that he served arrest warrants on individuals when in fact he hadn't. And testimony at trial showed that these individuals he was claiming to serve, he never even come into contact with. And originally the trial court agreed with the defense that there was insufficient evidence of conduct. And the Nevada Supreme Court overruled that decision, reinstated the jury's verdict, again finding that it's the jury's job to infer intent from conduct. And there was substantial evidence introduced at trial regarding the defendant's conduct. The state introduced documents from court and clearly established that the defendant filed them. It was his name in the upper left corner of these documents. It was his name on the March 13th filing, which contains a certificate of service with the defendant's signature, certifying that it was served on opposing counsel. Witnesses testified that they observed the defendant in areas where these documents were filed. The jury watched the jazz video of the defendant perjuring himself regarding his income, and in that video he acknowledged completing the financial disclosure form, which he signed under penalty of perjury. There was clearly more than sufficient evidence in this case to convict the defendant of the charges. And if defense counsel feels the evidence was insufficient, he may file an appeal and claim insufficient evidence was presented. The appellate court will have the benefit of having a complete transcript for review in the course of its decision. Now, regarding the motion for a new trial, I won't belabor the fact I addressed this in my opposition. An alleged selective prosecution, vindictive prosecution, an alleged lack of comity. These clearly can't be the basis for granting a new trial because they wouldn't be cured by granting a new trial. And vindictive prosecution has been addressed multiple times and has been denied by your honor multiple times. I won't belabor that. The defendant's motion provides no analysis or explanation as to how a random Facebook comment amounts to newly discovered evidence in this case. The motion just lists the criteria for newly discovered evidence and then just simply concludes that it constitutes newly discovered evidence. The evidence is that which tends to prove or disprove the existence of an alleged fact. I don't see how this statement on Facebook proves or disproves anything. The defendant claims in his motion that it would assist in discrediting the state's witnesses when that's been held by the Nevada Supreme Court on its own to be insufficient to constitute newly discovered evidence. It does nothing to discredit the testimony of Detective Standing or Marshal Willick. The Facebook post itself just says, I hope the Sanson supporters know that this could happen to them. I don't see how that contradicts any of the testimony that was introduced at trial from any of the witnesses. It certainly doesn't constitute newly discovered evidence. It couldn't be used at trial because it would be hearsay. I don't see how it could even be used for impeachment because it's not a statement made by any of the state's witnesses. And the comment is the opinion of the Facebook commenter with no apparent connection to this case. And on page 11 of his motion, the defendant lists all of these supposed untruths made by Detective Stanton, but these allegations have no connection to the Facebook comment. And much of this is just a regurgitation of defense counsel's closing argument. I don't see how this Facebook comment means that Detective Stanton knew he left the initial Facebook post, which led to him investigating in this case, or how this has any connection. The comment about Facebook not allowing anonymous postings, defense counsel is just regurgitating the same argument made at trial. At trial, defense counsel asked Detective Stanton, so this was an anonymous post we were investigating, and he responded yes. And the jury observed that testimony, so obviously defense counsel's desire to just repeat this argument and take another crack at impeaching Detective Stanton cannot possibly be newly discovered evidence. This Facebook post isn't even evidence at all. And it's not even clear what the Facebook commenter meant by that statement. I hope all other Sanson followers know this could happen to them. I see no way that this is evidence of concerted political activity. It's open to multiple interpretations. The defendant is not entitled to whatever interpretation he chooses. Regardless, and what occurred in this case, the defendant was a litigant in family court, like many people are. He had a number of hearings in the course of his divorce, child custody hearings, and all of the things that are related to family court. He became involved with Veterans in Politics International. He obtained jazz videos from his family court hearings. He began posting them on YouTube, both on his own YouTube channel, as well as that of Veterans in Politics International. The defendant would post links to this on Nevada Court Watchers, the very Facebook site that defense counsel was complaining about. So people who were on the Nevada Facebook site began watching the defendant's videos, and he even posted a video. The defendant posted the video in which he perjures himself, and someone noted that the judge was commenting that there appeared to be a forged letter that he filed. And eventually that's what led to Detective Stanton investigating in this case. It's been repeatedly explained to defense counsel in my oppositions that speculations as to the motivations of those who post comments on Facebook do nothing to negate the defendant's guilt. And the only connection that the Nevada Court Watchers Facebook site has to this case is that it's the Facebook page that Detective Stanton observed that caused him to investigate the defendant's activities. The detective had no need to investigate the motivations of the individuals who posted statements. He was investigating whether the content of the statements were true. There's no legal requirement that those who provide information to the police, whether directly or indirectly, regarding criminal activity have pure motivations. If there were, it would be nearly impossible for law enforcement to investigate anything. Detective Stanton was just doing his job by investigating this.
Yay, Lori Love!
Receiving this evidence by filing charges. And I find it deeply ironic that throughout the motion, defense counsel is just presenting this ipsy-dixit that Detective Stanton perjured himself, while in the same motion, defense counsel argues that there was insufficient evidence as to the defendant's perjury. Never has the defendant provided any legal support for his argument that an alleged political conspiracy is grounds for a new trial or for dismissal of any charges. There's no statutory basis for this post-trial discovery motion. As my co-counsel eloquently stated at trial, what happened in this case was far more boring than the defense counsel's version of events. What happened was the defendant committed criminal offenses, and he got caught. That's it. And all of these allegations that defense counsel was making concerned the manner in which he was caught. And there's been no legal or factual explanation as to how any of his claims regarding the manner in which the defendant was caught for his criminal activity negates the evidence of his guilt. And courts don't have the authority to dictate who law enforcement investigates, or for the most part, even how they conduct that investigation, unless law enforcement runs afoul of the defendant's constitutional rights, which didn't happen here. There's simply no legal basis for granting any of these motions. Sufficient evidence was introduced at trial. Far more than sufficient evidence was introduced as to the defendant's guilt. The defendant has not presented any legal basis for granting a new trial, and there's certainly no statutory basis for this discovery motion. It's a frivolous motion. All three of them, and they should be denied.
Thank you, McDonald.
Thank you, Your Honor. My colleague, misses a couple things. One, record reflect, this is a post-trial motion. I do not have the advantage of having the transcript from the trial, so these are from those who remember. So that's the source material. Number two, my colleague in her indignation misses the key point, and she still didn't take up with the challenge that I asked her to do. There is no linkage between the videotape they saw and intent to commit perjury. That's the practical problem. You saw a guy who didn't have a lawyer getting beat up by a guy who did. That's not a criminal intent. And number two, my colleague still doesn't show that there was intent to defraud. Now, and the other fundamental thing, the court controls its courtroom. I've been in here plenty. I've been in here, respectfully, Judge, watching you control civil docket. All right? You yell at people all the time when they're out of line. That's your job. Now, the judge who presided over this trial didn't do that. didn't see fit to do that. The state intervened. We're going to substitute the executive branch's decision for the judiciary. And that case is actually still proceeding down there. This is a usurpation and a violation of constitutional separation scheme. We don't like the judge's ruling. We'll be the judge for him. We're going to intervene for this family court. No, you're not. Okay, we'll file new charges in. That's exactly what's happening here. Now, this is not a legitimate criminal prosecution. My colleague still has not, will not ever point to another case like this one. And why Mr. McDonald gets singled out. And the answer is he's tied closely to Mr. Sampson. Mr. Sampson and Mr. Willick are in litigation as they agreed to. So Mr. Willick's minions, through his organization here, plans, they give evidence, and even so Mr. Judicial admits it. I was one who did it. Judicial's the one who did the same case down the hallway. So and then Willick comes in here and attempts to be an honest broker of information. This is not a trial, this isn't a case, and it should be dismissed. And despite our indignation, all three of these motions are meritorious.
Okay, thank you. Certainly, we have at least twice, if not more, gone over the motion for vindictive prosecution. I laid out my reasoning at least twice during the trial, but I'm denying
Your Honor,
that.
before
Mike?
may I
Mike?
pick up additional facts
Mike?
and rebuttal in support of this motion, Your Honor?
No, your attorney is speaking on your behalf.
Micah, you can do that.
Hey,
You're
Your
not.
Thank you. So, as I said during the trial, and I believe just before the trial, that there were no grounds to show this was vindictive prosecution. The state is given considerable latitude in determining what cases are brought, and the court doesn't, except for constitutional grounds, have, if you will, jurisdiction. And you mentioned that the separation of powers to somehow wave my magic wand and say, oh, I think this was inappropriate, even though it doesn't violate constitutional grounds, which I will get into, because your other part of the motion is, was there sufficient evidence to support the jury's decision that they decided, after hearing the evidence, that Mr. McDonald committed those crimes. There's video evidence, as we've all talked about, regarding his testimony in family court under oath, and the fact that he was clearly working when he denied that. And certainly a jury could, and a reasonable person, a reasonable juror, could find that he violated the statute. And therefore, the grounds for a new trial, being that there's no evidence to support the conviction, are clearly belied by the testimony that was solicited.
And the
It is
evidence.
not for, under 175-381, for the judge to substitute.
The theory that there was no evidence for this conviction is belied by the evidence of this conviction.
his or her decision-making for the 12 jurors who sat in judgment. As far as the
Snoopy, thank
selective
you.
enforcement, again, that was discussed at least twice during the trial, and I understand you want to make this argument so you can, similar to in a civil case, making a motion for a directed verdict, you have to do it. It's not the same in criminal, but I certainly don't object to your making the argument, but it is more appropriate for the appeal. And the same argument regarding vindictive prosecution and selective enforcement were made, as I said, twice prior to today. This is the third time. Your argument that somehow the detective who initially started investigating because there was an allegation that the defendant did not live where he said he lived at the time he filed for elected office. My recollection, and we don't have the transcript, was that while he was doing all that, he was advised of these other issues. And so even though he determined that Mr. McDonald was living where he said, he had found other issues that were the subject of potential prosecution, which later turned out to be why we were here. As far as the third rounds, if you will, that there is additional information from Facebook.
Happy birthday, Kit Kat. Happy birthday. Everybody comment happy birthday to Kit Kat.
Which doesn't seem to, and certainly in my mind, impact the allegations in our trial, other than that I guess you're alleging that the source of some of these allegations was the person who posted on Facebook, and whether or not that's a reliable means or not is, again, not for me to decide. But your comments that somehow, or your general comments that Facebook isn't anonymous is both true and not true. You can have a Facebook page, and this is just from, the little I know, and have it set up with some basic, I don't know if you'd call it pseudonym or something besides that. Yes, this individual does say he's the one that advanced it, if you will, and does give his name. You're right to, in that regard, but posting on a website doesn't, to me, you haven't made an argument that somehow that's going to lead to evidence which would be admissible in this case for a new trial to, I'm not sure who you would even be trying to impeach unless it's Detective Stanton. You did an excellent job of doing that at trial, and Mr. Willick also. I can't recall exactly, but I know he was on the stand for well over an hour, and cross-examined at length regarding his links to all of that, including the individual who, somebody from his office. So impeachment of him was quite thorough. That was the third ground. As far as all of that, I'm denying the motion to set aside the jury verdict and or a new trial and for discovery of some unknown Facebook evidence which is not relevant to the charges in this case or the trial for that matter. So based on all that, prepare an order.
I think Your Honor, appreciate the thoroughness of the analysis, if respectfully disagree.
I totally understand.
Your Honor, may I ask that Mr. McDonald be released on his own cognizance? He's got almost 8 months in custody in this case. He's got no prior criminal record and no history of violence. He does have, which is one thing that did come on trial, he does have very good IT skills. And he can contribute to the community with an admonishment not to have any contact with any parties in the lawsuit or his family or his children.
And Your Honor, the defense counsel already filed a written.
Yeah, and that's on, and one of the first things I was taught when I took over criminal was that those motions have to be in writing, which you did, and it's on for Monday.
All right, thank you, Your Honor.
Thank you.
Oh my goodness, my coffee's here and the video's over. While you guys watch these credits, I'm gonna go get my coffee.
335-284.
Good morning, Your Honor. Aaron Mistrial on behalf of the state.
Good morning, Your Honor. John Fowler on behalf of Attorney Craig Miller, Article 15019, on behalf of Mr. Michael McDonald. Attorney Miller, Your Honor, had to be down in Judicial this morning for a trial. We're going to ask that this matter be set over for another day.
Your Honor, the state requests that you rule on this motion today. I think Your Honor has more than enough information to do so. I think you make that decision based on the pleadings and your observations of the defendant.
Well, he's gonna stay in custody, so I don't see the harm in it's. Oh, right, so it'll be a week.
It is October 14th, 9 a.m.
Thank you, Your Honor.
Right.
Of course. Of course it stopped. Of course it did.
Apologize for being late, Your Honor.
Mr. Maynard, it is you're almost 45 minutes late. No no email, no call, no contact. It's unacceptable. (684-1) State of Nevada versus Michael Lee McDonald. Good morning. Good morning. All right, so this was sent to overflow when I was out. Judicial College, it's back. Where are we and when shall we set this? Are we ready to go?
And, yes, Your Honor, the state, for the record, Karen Mischler and J.C. Brahman on behalf
Good
of
morning.
the state. We request that you set the trial as soon as possible. It should not take more than 3 days.
Okay. Counsel, are you ready to go to trial?
We are ready to go to trial, Your Honor. We would like to address his custody status first.
I will address custody status orally. It does have to be put in writing. Okay. So if you want to file something, we'll put it on calendar as soon as possible, but that's the,
Okay,
That's
in
my
that case,
policy.
what is the soonest that the court can put it on? What time are we talking?
well, let's see here. We can put it on Monday. The parties can be ready. Can you be ready Monday? We have.
I don't know if our witnesses can be available on Monday, and, we would have to check with them, but in theory, the state could be ready.
Would you be ready, counsel? If you have any witnesses, I don't want you to give away your case, but do you anticipate being ready?
I believe we could be ready Monday. If there are any complications, it would take a very brief
I have
amount
no
of time
idea.
to catch up on that, in which case
Okay.
we could.
Well, here's what I want to do. I'm going to be out tomorrow, but I could set it for a status hearing this afternoon to confirm that you'll be ready to go, so you have time to contact your witnesses. Would you be willing to come back this afternoon?
Sure.
Could you? Okay. How about 2:30? Does that work for everybody?
That works for those states.
All right. So we'll pass this till 2:30 this afternoon, and we can figure out what we're going to do. Okay?
Okay.
All right. Thank you.
Thank you, Your Honor.
Just sit back and watch. We'll figure it out.
Good afternoon. 1 second here. I guess we should bring the defendant out. Good afternoon, Mr. McDonald. Your attorney still isn't here, so I'm just going to put a few things on the record. I wanted you to be here, okay? So this is case number C-18-333-684-1, State of Nevada versus Michael McDonald. Who's present from the state?
Karen Mischler and J.P. Brahman on behalf of the state.
All right, thank you both. And I'll note the defendant is present in custody without his attorney present. I'll also note this morning during calendar call at 8:30, I asked the parties to come back at 2:30 today to ensure that we are ready to go to trial on Monday. Counsel for both sides, including counsel for the defendant, indicated that was not a problem. They would be here at 2:30. At 2:30, the state was present. Defense counsel was not present. It is now 3:10 in the afternoon. Chambers has reached out to counsel's office twice already. About 5 minutes ago, we received a message that counsel was in the elevator. 5 minutes have, if not more at this point, have passed and he is still not present. So I'm going to ask the state first if you're ready to go to trial.
The state is ready, Your Honor.
Okay. All right. Then I am going to set this for trial on Monday. We will start trial after I finish my morning calendar. Is it? Okay, good. Let's see here.
Yeah, we can start.
All right, good. We will start at 9:30 in the morning. I'll also note for the record, at the calendar call this morning, Mr. Maynard, who was present on behalf of the defendant, indicated he didn't think it would be an issue to start trial on Monday, and so that will be the order of the court. Oh, look who just walked in.
I just checked. It was Wednesday. October 23rd was a Wednesday. So it's not like she's saying on Friday we're going to trial on Monday. No. It's fine. She's saying on Wednesday we're going to trial on Monday.
Apologize for being late, Your Honor.
Mr. Maynard, it is you're almost 45 minutes late. No
Yes.
no email, no call, no contact. It's unacceptable. I just set the case for trial on Monday to start at 9:30 in the morning. I did reach out, my chambers reached out to your office. We were advised you were in the elevator, at this point, almost 10 minutes ago. It is unacceptable, and in this department, maybe other departments are more flexible. At a minimum, you need to have a courtesy call placed to Chambers, so we're not waiting around for you.
Absolutely, Your Honor. I personally apologize. Won't happen again.
I appreciate that. I'm assuming that isn't an issue. You said this morning it wasn't an issue to start trial on Monday.
Actually, I've had, since had the chance to discuss it with Mr. Mueller, I don't think that we will be adequately prepared for trial on Monday.
How come? You were ready this morning.
I thought we might be ready. This has not ever at any point in time been primarily my case, more than capable of coming in and making an appearance. I did need to check with Mr. Mueller. There is some additional work that we need to do, some additional research. We need to have,
Research as to what?
he needs to have some, several witnesses here. He needs to figure out where they are and get them brought in and get them ready to go.
Have you been noticed of any witnesses being called in this case?
No, none by the defense, Your Honor. And this would also be the third time, I believe, that the defense has requested a continuance.
And any previous times, have you been noticed of any witnesses, potential witnesses being called?
No. And they previously announced ready.
Sure.
If they're waiting for Michael to stop talking, we're going to be here for a long time. Guess who's back? Back again. Doctor's back. Oh, I got someone worse than chili on Monday. Guys, clear your calendars for Monday. Clear your calendars for Monday. Because right after Judge Fleischer's docket is over, we're going to have a special live stream. And it is so good. It is so, so, so good. I've watched it a bunch of times so far because it's just so good. And it's going to surprise you because we've been here before. Oh, it's really good though. What, is it good? Oh, yes, it's very good. Thank you for asking. It's very, very good. I don't even want to do Michael McDonald anymore. It's hard doing this because I just want to do that one so bad. Oh, no, that would make it epic. But no, there's no taser. But it's so good. Maybe, Michael. I'm going to go with a maybe. Hi, Linus. Oh, he's so... Oh, man.
All right, counsel, are you ready?
Your Your Honor, we would be asking for a continuance to the first week of November, if that is at all possible. I'm trying to thread a needle here and solve as many problems as I can in a very short order with very few moves. We don't have anything else scheduled presently for the first week of November. It would give Mr. Mueller some amount of time to do whatever he needs to do, which quite frankly, at this point in time, I'm unclear as to exactly what he does need for preparation. He said that he would be uncomfortable going next week, giving another week.
All right, it's my understanding that both parties announced already when I was out at Judicial College, was it 2 weeks ago or 1 week ago? It was scheduled to go to overflow, but then overflow couldn't accommodate the schedule, so it was kicked back to here.
That's correct.
All right, so your request for continuance is denied. Both parties announced already less than 2 weeks ago. I'll also note that NRS 174.234 specifically requires that that there's reciprocal discovery, specifically a reciprocal disclosure of lists of witnesses, and also talks about expert testimony. But in this particular instance, it's a requirement of reciprocal disclosure of lists of witnesses. This case has been set for trial at least twice, if this is the third or the fourth time. And I said, as I noted, less than 2 weeks ago, both parties announced ready. There was no disclosure of witnesses. There is still no disclosure of witnesses. And I don't have a sufficient basis before me to grant the defendant's request for a continuance. I understand everyone's schedules can be busy, but we specifically requested this continuance to make sure the witnesses could be in order. I asked if there were witnesses you would need to call, and where I needed that information this afternoon. It was at that point this morning I didn't realize that no witnesses had been disclosed. So we will start Monday at 9:30 in the morning.
Judge, can I make a request, please, that the attorney come visit me and do a list of witnesses and actually come to discuss the defense with me, please? I would like to be completely prepared. I do believe this case, that he's going to be filing a motion to dismiss based on Lane versus Allstate, so I please ask that this order comes to something to be able to.
A motion to dismiss can be filed anytime before the commencement of the trial. So today's Wednesday, that could be filed over the weekend. But that doesn't mean that I'm going to grant it, entertain it, or entertain any argument as to it. I'll certainly review that. If I do think it warrants a response, a written response, I will ask the state to do that in short order. What was the case you cited?
Lane versus Allstate.
Lane versus Allstate, L-A-N.
No, this is not an appeal. While we were in with Judge Marquis, he violated the protection order. So they're going forward with a trial for his violation of protection order. So that's why we're here. And I don't know, they look kind of loose. They don't look like bandages. They don't look like they're really tight on his arms like a bandage would be. I think they're just with the handcuffs.
E?
Yeah, L-A-N-E versus Allstate, it's case law already that this has already been adjudicated, that somebody gets wiretapped or records themselves, it wasn't, they're unaware of the state statute, that they dismissed the case, which it has been dismissed in the past, so that's why I'm asking. But I'm sure they'll file a motion for that as well.
Well, they could file a motion for that, and I will take a look at it. I will also note that this case has been around over a year. I don't know why such a motion would not have been filed previously. I can only assume it was filed on July 25th of 2018. Perhaps in their professional responsibility, applying their professional responsibility duties, they determined that doesn't apply or would be inapplicable in this instance. I don't know. But certainly a motion to dismiss based on that would be considerably untimely unless it's a brand new case or there's intervening case law between July 2018 and today's hearing. So again, I don't have anything before me that would warrant a continuance at this time. I cannot order your attorneys to go see you. I assume they will go see you prior to trial in order to prepare for trial on Monday.
Your Honor, may I place something on the record?
Yes.
And Your Honor, 1 week ago, there was an offer relayed to defense counsel to resolve the case. The offer was for the defendant to plead guilty to 1 count of unlawful interception of wire communications, a category D felony. In this case, the state would retain the right to argue at sentencing, but would not oppose that sentence running concurrently to the defendant's other case, C-335-284. And when that offer was relayed, it was by email last week to defense counsel with the understanding that it would expire at overflow last Friday. And so that offer is now revoked.
Understood. Mr. McDonald, did you hear what she put on the record?
Yes, it did, Judge, and it was originally appealed for conspiracy to commit wiretapping, perjury, and wobbler in this case can be resolved. I should have been more informed on that because I would have been out of jail a long time ago and moved on with my life, so, but yes, Judge, I can.
Was that a prior offer that also expired?
I believe he's referring to an offer that I made prior to preliminary hearing in this case, which would have been over a year ago. I don't remember the exact terms, but I think he's somewhat correct there.
So anytime that there's an offer made before preliminary hearing, the offer is always better because that is generally, not always, but generally it is better because that will resolve the case early, prevent the preliminary hearing from going forward. And at that time, after the expiration of that, it's the state's prerogative as to what offer is appropriate. That offer was made and extended with the explicit caveat that it would expire at the calendar call for overflow last Friday, which would have been the 18th of October. So just to be clear for the record, that means you all would have announced ready on October 16th. That
Yes,
Wednesday? Okay. All right, so less than a week ago, the parties are ready. There were no witnesses, there were no motions pending. I'm sincerely concerned about the reasons placed on the record for the request for a continuance at this time, but again, I don't have any information before me to grant that continuance. So, are you affirmatively rejecting that plea, Mr. McDonald?
The one that she just stated?
Yes.
Judge, right, yeah, yes, Judge.
Okay,
Whether
all
it's
right.
fixed for trial, there's no merit in the case.
Okay. I just want to make sure we're clear that you're affirmatively rejecting the offer. Thank you for putting that on the record. I appreciate it. Anything further?
And just, Your Honor, I'm not familiar with your method of jury selection and
Sure,
what
fair
our
enough.
schedule would be.
Lori, that
So I line them up
sucks so bad.
starting 1, 8, 24. So I do 24 total. I'll ask a number of questions. I would like the parties to submit their questions to Chambers ahead of time just for me to review them. Sometimes I ask them those questions, sometimes I don't. If there are any questions I feel like they should not be asked, whether by myself or from you all, I'll let you know ahead of time. And then I'll let you all do your own jury selection as well. With this type of case and this, how many witnesses do we anticipate calling?
3.
Okay, so, I don't think anybody specifically, potential jurors, like jury selection to be drawn out. But you all experienced attorneys, I'm sure you can read the jury's demeanor. But I anticipate we would be able to finish jury selection on Monday. Depending on what time we finish, we could do openings and call one witness or just do openings, and then we'll finish the other days. My only challenge next week is I have something that I cannot miss starting at 3:30 on Wednesday. So if we are not done by 3:30 on Wednesday, we'll recess for the day and come back Thursday. But otherwise, we'll go after my calendars all day.
Oh, we won't be done. Don't worry.
Honestly, if things were very efficient, not saying the court isn't, this could be a one-day trial.
Okay, fair enough. Yeah.
It can't be a one-day
Question
trial.
about the
Nope.
Wiring questions. In submitting them to Chambers, are we to submit them ex parte, or are we CCing our opposing party?
No, you could submit them ex parte, and I'll take a look at them before we start the trial. Okay?
Wonderful.
All right. And I would ask that you do that no later than Sunday evening, so I have them by Monday. If you could do them by Friday, I'd appreciate it, but Sunday evening is fine. I'll still review them.
Yes, sir.
What time will we be starting on Tuesday and Wednesday?
Tuesday. I have a lot of civil stuff on. I anticipate we'll start closer to 10 on Tuesday. I have
Epic.
several motions
Thank
for
you,
summary
Linus.
judgment
Thank
that
you.
might take a minute. though those have a tendency to get moved as we get closer to the calendar. And then I have a couple of status checks, but those are fast. So about 10 o'clock on Tuesday, and then on Wednesday, 10:30.
Thank you, Your Honor.
I'm sorry, what was the time on Tuesday?
I anticipate 10 o'clock, and Wednesday, 10:30.
Brick in the wall. Congratulations.
All right, anything further?
No, Your Honor.
Okay, great, thank you very much. We'll see you all Monday.
Secret McSquirrel. Love it. Cat and Whisperer. My cats need more than a little whispering right now. I'm up to here with them.
Ready?
Yes, I am, Judge.
Page 9, McDonald.
State of the average is Michael McDonald, C18-335-284.
Thank you, Your Honor. Craig Miller back from Mr. McDonald. This is
I have to think that this is still the violation of protection order hearing because it's so close in time.
on for a motion for owner cognizance. Mr. McDonald's got about 7 or 8 months of credit on this case already. It's a non-violent felony. The allegations here is Mr. McDonald was being investigated because he was reportedly not living in his assembly district that he was running for. After the detective decided he couldn't find anything wrong there, he then decided to go through his divorce pleadings. And apparently Mr. McDonald wasn't a good enough attorney representing himself that he got sideways on some paperwork, including his financial affidavits. As I stand here, Judge, and I know as a former family court practitioner yourself, this man is in custody as a result of self-representation in family court. I'm going to ask the court to give him an owner cognizance, and he'll be here for sentencing. Mr. McDonald has previously posted $100,000 bail. He has ties to several prominent families and actually several prominent elected officials. He's not going to go anywhere. He's appeared every day. In fact, he's appeared in my office a little too often to help me with this case.
Wait a second. Did you hear what he said? He posted $100,000 bail. And he puts like zero to pay no child support.
Diligent and industrious man with a set of ideas that apparently rubbed a few people the wrong way. He'll be here for sentencing, and I'm almost certain he's a good candidate for probation.
Well, I realize this all originated in a family court. The victim in the case is the defendant's ex-wife. He was directed to stay away from her, and he apparently can't do that.
Well, what he did do, Judge, was he mailed his...
I know what he did.
He mailed a couple gifts to his kids. And no offense, I mean, I've made a career out of successfully staying out of family court and will continue to do so. Why that institution even exists is actually beyond my comprehension. I don't see that it's worth the taxpayers' money, but that's a different discussion. Having said that, Judge, the question here is, Mr. McDonald, 0 felonies, 0 misdemeanors, 0 violence, 0, 0, 0, 0, 0. He unfortunately ran some people the wrong way down in family court. Now, he did stay out of trouble for the better part of a year. He made $100,000 bail. He's not a flight risk. He's got literally, I don't think he's ever lived anywhere else in his life. He's not going anywhere. I'm going to ask for a loan of cognizance pending sentencing.
Sentencing is October 30th. I mean, it's sentencing is right around the corner.
Can't stand this lawyer.
Family court's involved in this matter. The directive for the defendant to stay away from his ex-wife, that came out of family court, didn't it?
Not just family court, Your Honor, and for the record, Karen Mishler on behalf of the state. The defendant was ordered both in this case, the criminal case, to stay away from his ex-wife Candace Ruiz, as well as there was an order in family court to not have contact with her as well.
She's so pretty.
He was not to have contact with the children either. And Your Honor, if I could bring up something else I'm not sure Your Honor is aware of. The defendant was released on mid-level electronic monitoring in this case in April, and then he was remanded on this case on July 22nd, not just for contacting his ex-wife, but he also was showing up at the DA's office's CLEs and demanding to be present at them, insisting they should be open to the public, and then he ran off with our CLE schedule, stating that he was going to show up at them, and the DA's office had to increase security measures. And now the only thing that's changed since July 22nd is that he's now been convicted of 10 felonies. So the state is also concerned essentially for the safety of the DA's office as well.
0 violence, 0 arrests, 0 criminal history, and all he did was get sideways with the powers of political correctness.
0 violence?
And Your Honor, the defense counsel keeps repeating and claiming that the defendant has no criminal history. Repetition of a falsity does not magically transform it into truth. The defendant actually has multiple misdemeanor convictions for resisting arrest, as well as battery domestic violence and violation of the domestic violence related TPO.
All of which started in family court where he made the mistake of taking a submittal stay out of trouble dismissal order. Then someone took advantage of him and made sure they filed charges against him. This is the most politically motivated prosecution I've ever seen, including the bidding case, Judge. Nothing about this case is clean, and none of it will stand up in district court and in front of the Nevada Supreme Court. I'm asking him to be released. We're gonna,
Was his $100,000 bond that was that exonerated when he got arrested? I assume it was. Pretty good.
I believe it was, Your Honor.
I'm not going to do more, but I am going to set bail at $1,000 on each of these. I have 11 counts, not 10.
He was found guilty of 10 of the 11 counts.
So there's 10 counts, and then bail's $1,000 on each count with high-level electronic monitoring. So he has to post $10,000 and be subject to high-level electronic monitoring. And if your ex hears a peep out of you before your sentencing, you're going to be held without bail, period. You understand all that?
Yes, sir.
yes, sir.
All right.
That's it.
Goodbye. Be back here on the 30th for sentencing. All right.
An opening statement is a synopsis or an overview of what the attorneys believe the evidence will be. Opening statements of the attorneys are not evidence. After all, the attorneys are not witnesses to any of the facts in controversy in this case. After openings, the state will then call any witnesses and introduce any evidence accordingly. And at the conclusion of their case, the defense may decide to call witnesses and submit any additional evidence if they wish to, but they are not required to do so. After the defense rests, the plaintiff may have the right to call rebuttal witnesses. After all of the evidence in, I will instruct you on the law that applies to this case. You must not be concerned with the wisdom of any rule of law stated in these pre-trial instructions or with the instructions given to you at the end of the trial. Regardless of any opinion you may have as to what the law ought to be, it would be a violation of your oath to base a verdict upon any other view of the law than that given to you by the court. After the instructions on the law are read to you, each party has the opportunity to argue orally in support of their case. That's called closing argument for submission. Again, what the attorneys say during that is not evidence. Their arguments will be designed to help summarize and interpret the evidence for you and show you how the evidence and the law relate to one another. Since the state has a burden of proof, in this case, beyond a reasonable doubt, the plaintiff gets to argue twice at the end of trial. The state gets to argue, and the defense gets to argue their closing arguments, and then the state gets to put on a rebuttal argument, excuse me. I just mentioned that the burden of proof in criminal cases is beyond a reasonable doubt. That's different than civil cases. In civil cases, let's say it was a car accident, In civil, it's preponderance of the evidence, meaning if we were looking at rating justice here with no scales, you would weigh all the evidence and see where the scales tip, and that would be the person who wins. In this criminal case, it's beyond a reasonable doubt.
Happy
No real
Valentine's
instruction as to
Day.
what that means, and I'm sure the state will discuss that during the presentation of the case. It is not beyond all doubt, but it is beyond all reasonable doubt. You get an instruction as to that. After the attorneys have presented their arguments, you will retire to select a foreperson to deliberate and arrive at your verdict. Faithful performance by you of your duties is vital to the administration of justice. It is your duty to determine the facts and determine them from the evidence and the reasonable inferences arising from such evidence. And doing so, you must not indulge in guesswork or speculation. The evidence which you are to consider will be the testimony of witnesses and any exhibits admitted during the course of the trial. I just got a new phone and it's ringing in the middle of this instruction. Pardon me. Technology, our best friends and sometimes our worst enemies.
That was me calling her to tell her to stop talking. Sorry, Judge.
Admission of evidence in court is governed by rules of law. From time to time, it may be the duty of one of the attorneys to make an objection, and my duty as a judge to rule on those objections and decide whether a certain question may be asked and answered or whether certain evidence may be admitted. You must not concern yourself with objections made by attorneys. Further, you must not consider anything which you may have seen or heard when the court is not in session, even if what you see or hear is said or done by one of the parties or one of the witnesses. While you hear the courthouse, please always wear the badge the marshal just gave you. Did they have the badge in it?
No, Your Honor.
Okay. The
Can
badges
I-
you will get, you'll see he's one of those blue badges.
Can I fast forward jury instructions, please, please, please? Thank you.
If you would like, before you start, would you like my court with me to read the information, or would you like to read the information?
Oh,
If you don't mind, I apologize.
you can read the information.
So we're going to read information, which is a charging document. That's what it is a document. It is not evidence. It is not evidence of guilt. It's merely to inform you of the charges and defendant is facing. Okay.
District Court, Clark County, Nevada, the state of Nevada plaintiff versus Michael Lee McDonald, defendant. Case number 3336840, Department 9, amended information. State of Nevada, County of Clark. Stephen B. Wilson, District Attorney within and for the County of Clark, State of Nevada, in the name and by the authority of the State of Nevada, informs the court that Michael Lee McDonald, the defendant above named, having committed the crimes of unlawful interception of wire communications on or between August 1st, 2016 and November 30th, 2016, within the County of Clark, State of Nevada, contrary to the full enforcement effects of statutes, in such cases made and provided and against the peace and dignity of the State of Nevada. Count 1, unlawful interception of wire communications. Did willfully, unlawfully, knowingly, and feloniously intercept or attempt to intercept a wire communication without the knowledge or consent of Candace McDonald and or Candace Ruiz by recording a phone conversation between the defendant and the said Candace McDonald and or Candace Ruiz without her consent, wherein they discussed daycare costs. Count 2, unlawful interception of wire communications. Did willfully, unlawfully, knowingly, and feloniously intercept or attempt to intercept a wire communication without the knowledge or consent of Candace McDonald and or Candace Ruiz by recording a phone conversation between defendant and the said Candace McDonald and or Candace Ruiz without her consent, wherein they discussed doctors, child protective services, and other allegations against her boyfriend. Count 3, unlawful interception of wire communications. Did willfully, unlawfully, knowingly, and feloniously intercept or attempt to intercept a wire communication without the knowledge or consent of Candace McDonald and or Candace Ruiz by recording a phone conversation between the defendant and the said Candace McDonald and or Candace Ruiz without her consent, wherein they discussed her new boyfriend and or the dietary needs of the children. Count 4, unlawful interception of wire communications. Did willfully, unlawfully, knowingly, and feloniously intercept or attempt to intercept a wire communication without the knowledge or consent of Candace McDonald and or Candace Ruiz by recording a phone conversation conversation between the defendant and the said Candace McDonald and their Candace Lewis without her consent, where they discuss family court proceedings. Count 5, unlawful interception of wire communications. Did willfully, unlawfully, knowingly, and feloniously intercept or attempt to intercept a wire communication without the knowledge or consent of Candace McDonald and or Candace Lewis by recording a phone conversation between the defendant and the said Candace McDonald and or Candace Lewis without her consent, where they discuss court issues and other dietary needs of the children, signed by the district attorney to which the defendant has pled not guilty. Thank you, and apologize. Now, when you're ready.
Thank you, Your Honor. Ladies and gentlemen, the evidence in this case will show that between August 1st of 2016 and November 30th of 2016, the defendant, Michael McDonald, recorded 5 different phone calls that occurred between himself and his ex-wife, Candace. These calls occurred without Candace's knowledge. These calls were recorded without Candace's knowledge or her consent, and that is why we're here today. Now, I want to give you some background. You'll hear testimony from Candace, the defendant's ex-wife, and you'll hear that the defendant and Candace, they met in 2008, they got married in 2010, and then they have 2 children together. And their youngest was born in 2014. Their daughter, she just recently, a few months ago, turned 5. She's the one that you'll hear most about. The defendant and Candace filed for divorce in 2015, and that divorce is finalized in October of 2016. But of course, since the 2 of them have children together, even after the divorce is finalized, they still have to appear in family court and work out issues related to child custody and child support. And the phone calls that you'll hear in this case occur around the time period when their divorce is being finalized. So some occur a couple months before, around August of 2016, and some a bit later. So some of these issues that they'll be talking about have to do with family court. Now, around the time that these hearings are happening in family court, the defendant becomes active online and posts a lot of videos from his family court hearings. He gets the video from the court system, and he posts some of it on his own YouTube channel, some of it on a YouTube channel for another organization, Veterans in Politics International. And occasionally he posts on a Facebook page known as Nevada Court Watchers. And Nevada Court Watchers is a Facebook site where people go on, they post a lot of information, they talk about a lot of hearings, things going on in the legal world here in Nevada, mostly here in Las Vegas. And it's kind of focused more on family court. A lot of these people are litigants who don't have attorneys, so they're just kind of asking each other for advice about what's going on in family court. They talk about a lot of different cases. And the defendant starts communicating with Mark DeCiro, and he's a witness that you'll hear from in this case. Mark DeCiro is one of the administrators of Nevada Court Watchers, and he sees these things that the defendant is posting online, these hearings. He sees his comments and his posts about what's going on in his family court case. And Mark's interested. This is the sort of thing that he posts on his Facebook site. So through Facebook, he communicates with the defendant, and he asks him for more details about his family court case, things that are being filed, hearings that are going on, just kind of wanting to know the status, if he has other information to post on his Facebook site, Nevada Court Watchers. And the defendant, he provides Mark DeCiro with a link to his Google Drive, or a specific folder in his Google Drive that contains a lot of documents and recordings related to his family court case. And Mark DeCiro, he doesn't notice at first because there's a lot of things in this folder. He looks at it, but eventually he looks in there and he realizes there are some recordings of phone conversations between the defendant and Candace. And Mark DeCiro is concerned. So he notifies Candace, and he sends her a link to these recorded phone calls, these audio recordings that are in the defendant's Google Drive. And of course, you'll hear from Candace, and she'll tell you that she listened to these recordings, realized they're phone calls that occurred between her and the defendant, and she can tell approximately when they happened based on certain things that they're talking about, certain things that were going on with her daughter and things that were going on with her family court case. and she had no idea at the time that the defendant was recording these phone conversations. So she notifies the police. And that's really what this whole case is about. These recorded phone conversations that occurred without Candace's permission. And that's why we're in court today. So at the conclusion of this case, I'm confident that you will find the defendant, Michael McDonald, guilty of 5 counts of unlawful interception of wire communications.
Thank you. Mr. when you're ready.
Thank you, Your Honor. Ladies and gentlemen, the jury, proper conclusion reached. The close of the evidence is not guilty. There is an individual down in family court by the name of Steve Sampson. He runs an organization called Veterans in Politics International. They are court watchers. They are watchdogs, people independently self-appointed, and they watch the shenanigans of and the foibles of family court. Mr. DeCiro represents a competing faction, something called Nevada Court Watchers. Nevada Court Watchers and this Veterans in Politics, they don't get along, and that's putting it mildly. There are lawsuits back and forth, defamation counts, and mutually bad feelings. Mr. DeCiro runs a website, and Madam Clerk, can I get this? No. Yeah, thank you. Evidence will show.
Bear with us as we transition from computer to the Alamo. It takes a minute to focus. There we go.
Mr. DeCiro is going to be a witness. He's the primary witness in the state's case. He's made his view of the subject eminently clear. You will hear, and the evidence is going to show, his testimony is to be disregarded. That's the Facebook page that Mr. DeCiro has produced. He's got a Mr. McDonald stick figure as the banner of his Nevada Court Watchers page. Mr. DeCiro has posted on this Facebook page his view of what is to happen. He says, trust me, anyone who wants to align himself with that being Sampson is going to go right down with him. The choice is theirs. So now Mr. DeCiro has made his view known that he doesn't like Mr. McDonald. He's also actually threatened anybody who associates with Mr. Sampson in writing. The evidence will show that Mr. DeCiro hacks into a Google account where he discovers an illegal recording, 5 of them. That's what he would like you to believe. There are, however, 4 or 5 practical problems. Mr. DeCiro is a radio guy, 15 or 17 years. He is proficient at audio editing. Unambiguously has the abilities and the skills to edit. So when he discovers these edited or these phone conversations, does he download them and hand them to police as the originals? No. The evidence is going to show that they are edited and the metadata for the recordings is removed. And they give this version of the audio transcripts to the police, who then, the evidence will show, made zero evidence, zero effort to determine if the audio recordings had in fact been altered. 5 phone conversations. They don't begin with hello. They don't end with goodbye. There's no time. There's no date stamp. There is no indication, in fact, that these snippets, they're not even phone conversations. There's 5 audio snippets that are purported to be conversations. And then the problems get even worse, because the evidence is going to show there's no proof anywhere in this case that Mr. McDonald actually made the recordings, other than the anger and bile of his ex-wife, who testified under oath, oh, I know he made them. But no proof. You literally are going to see a case here that has no evidence, and this is a political prosecution. When you go through, you'll see no independent verification, you'll see no metadata, you'll see no complete phone conversations, and the most scary thing, you may not even have a crime here. Because while a single party recording is illegal in Nevada, there are other jurisdictions, California, where it is not a crime. They don't even know where these conversations came from. let alone if they are phone conversations, what state they were recorded from. And most troubling of all, is they're from a hack. Mr. DeCiro, as you saw, has very strong feelings about Mr. McDonald and Mr. Sampson, but somehow Mr. McDonald just let him into his Google Drive account. When you get through with the state of this evidence, probably tomorrow, maybe early Wednesday, you're going to come back with a conclusion that the state cannot, will not, and has not proven the case, let alone proven it beyond a reasonable
Well, there goes the one-day trial theory.
doubt. Thank you.
Thank you very much, Mr. Mueller. All right, ladies and gentlemen, we're going to go ahead and end at this time. So you are in recess until 10:30 tomorrow morning. When you step outside, you'll get those badges we talked about. And if you haven't already collected your phone number, please provide your phone number, the best way to reach you, to the marshal as well. That way if anything comes up or we need to get a hold of you, we can do that via telephone. Thank you very much for your attention. Yes, your notebooks you're going to leave behind. So you leave them on your chair with your juror number. I saw a number there, right? Leave it on your chair, they'll be collected, they'll be passed out to you again once we resume tomorrow morning at 10:30. All right, thank you very much.
All rise for the jury.
This is a trial for wiretapping, for illegally recording conversations he had on the phone with Candace during the custody battle they were in. I have no idea what type of prison sentence or fine or fee or anything is involved with, illegally recording someone.
The Supreme Court has been
Hold on, I asked the state, as I understood, they have something to put on the record, so give me 1 second. Oh, you're right. Thank you. Yeah.
Supreme Court has said nothing for people about not having clients present.
No, that's completely appropriate, thank you.
Yeah.
All right. Please let the record reflect the presence of the defendant. Good morning, Mr. McDonald.
Good morning, Judge.
All right, state, go ahead.
Your Honor, several things. In no particular order, we just received defense jury instructions. We have not had time to go over them. I'm sure we'll go over them at lunch.
While we were on that subject, I've got 3 copies for the court as well. We've got cited in unsaid copy deeds that are all pretty generic statements of law. They don't anticipate them being particularly controversial. Here's the cited ones in the statutes, and here's the uncited ones for inclusion in the instructions.
Thank you. Okay.
Second issue. With regard to the defense's use, both in arguments before the jury came in and in their opening statements, a picture from a Facebook webpage where Mr. McDonald is presumably photoshopped into a prison or a jail clothing as Mr. Steve Stanson. Based upon the usage and opening, we're of the understanding that this is something that's going to be used in Mark Cicero. It's reported that Mark Cicero may have made this image to make fun of Mr. McDonald or for his own amusement or whatever his purpose was. State's concern regarding the use of that image is Mr. McDonald has a lot of issues in the criminal justice system. He has been in and out of jail for the last 2 years. So I'm afraid that the usage of that and the following of that with Mark Cicero may lead to other issues that are going on with Mr. McDonald. I have this entire municipal court record that shows his incarceration starting in, I believe, 2017 from 5 different municipal court cases for things such as stalking, harassment, and resisting a public officer. So that's one of the issues that we're concerned about regarding how the defense has portrayed this case in the open. If you want to address that now, I have two other issues that may be equal or more important.
Let's address that first.
Sure.
Mr. Mueller, what is your intention and where do you anticipate going with that picture?
I was not, and I apparently must be losing my touch, I was not subtle. I pointed out that Mr. DeCiro has a very strong grudge against Mr. McDonald. I used 2 images captured that I intend to use in court of about 35. I have, if there's any additional doubt that Mr. DeCiro was not an honest broker of information, I have literally a 4-inch stack of snarky comments, disrespectful quotes, assertions of ill will and motivation on behalf of Mr. DeCiro. I literally, we take all day to go through these.
Were those produced to the state as part of discovery?
These are not produced in the state in discovery, these are for impeachment, and they're off the web, and Mr. DeCiro is free to give to the state his copy of them. These are the ones I have.
If your case in chief is going to be comprised of solely impeachment material, tell me how that doesn't defy the reciprocal discovery.
Well, first off, Mr. DeCiro is actually in defiance of the court order watching us right now on this videotape. So let's, if we can have the camera turned off, or we're going to be giving Mr.
How do you
DeCiro.
know that?
It's not true with regard to that. Again, if you want to fast forward to the other issues, I clarified what Mr. Mueller is trying to allude to. It would be helpful.
Hold on, we're raising multiple issues. So, let's go back to the initial issue. Mr. Mueller, are you intending on eliciting information regarding your client's other criminal cases?
No. I intend to, as I stated in open, I intend to show that Mr. DeCiro has a very strong bias against Mr. McDonald, and since he is the primary, if only, witness against him, his bias is clearly a topic of relevance to the trial.
All right, so you introduced that in opening statements,
Yes, I
and
did.
so I want to be clear that if you decide to make reference to or suggestions of other criminal cases, you're potentially opening the door to discussion of those other cases as
I
well.
have no desire to talk about any of the other cases.
All right, I will also put on the record now that I will not allow for there being any misleading of the jury as to suggest that Mr. DeCiro put him in road. He would never do that, and not be the kind of person that has any contact with the criminal justice system, because that would be misleading to the jury. So, it's before the court, I recommend and I caution you to proceed lightly in how you use that picture.
Thank you, Your Honor.
All right, do you have any additional concerns regarding that particular subject matter?
I'm just not sure where Mr. Mueller is going to go with this. With Mr. DeCiro, he may be boxed into a position where he has to explain it in a way that would be potentially prejudicial to Mr. McDonald. Granted, it's all of Mr. McDonald's own doing and the defense strategies that they've taken, but it's a matter of fact that during the time when that photo was up, he was incarcerated. So it's not exactly to make fun of him. It would be unfair to portray that fact.
Well, again,
Yeah.
if he opens the door, I won't let you, build a mansion behind it, but I will let you walk through it, and to the degree that we correct the record and not become misleading to the jury.
We appreciate that.
And then I would request that both sides contemplate any curative instructions would be appropriate in light of how other door might be opened.
Okay. The other issues, and this is kind of, originally I thought it was two, but it's really kind of one combined issue. So the chronology of this is, I guess I'll tell you it from my perspective. I received an email, 3 emails from Mr. DeCiro at 10:27 p.m. I have copies of those.
Can I see them?
Sure.
Thank you.
Provided defense those, and I emailed them to him when I woke up this morning.
Thank you very much. All right, I'm not going to read them.
Based on what I see, these emails and their context of the evidence is, they appear to be the links that Michael McDonald emailed to Mr. DeCiro to let him into his Google Drive. How this all develops, and I spoke with Ms. Mishler this morning after I woke up and saw that these things had been emailed to me after I went to sleep, is that these appear to be material evidence in this case that corroborates what Mr. DeCiro would say happened, that Michael McDonald sent him these links as he was interested in his family court case, and from being allowed access to his Google Drive, saw these illegally obtained phone recordings of himself and Mrs. McDonald. Now, with the timing of this, and Ms. Mishler, co-counsel in this case, received an email from Candace McDonald / Ruiz. Was it last night or this morning?
It was actually sent last night, but I didn't see it until this morning.
On that email, she stated that she had watched the opening of state and defense. She indicated that the openings were live streamed by the media entity who is here today. With regard to Mr. DeCiro, because I was trying to figure out why the heck is this guy sending me these things, I called him up and I said, what's the deal with this? This is kind of a very late disclosure. And he said that he caught probably the tail end of Ms. Mishler's opening and about 5 minutes of Mr. Mueller's opening, and then he would get in the car and drive. Obviously, the chronology of this is we excused our witnesses at 4 p.m. We didn't start opening until 4:30. There was no exclusionary rule invoked until after openings. With regard to this, I believe Mr. DeCiro sent this to me because he heard how Mr. Mueller was calling him a hacker, and that's simply not the case. So as any layperson might do, they want to defend themselves, and that's why he sent this to, he sent to myself and Ms. Mishler. So that's the chronology of it.
Mr. Mueller, I'll hear from you.
Your Honor, it has been the council's contention that this was not this is a political organization, not a news organization. The fact that Mr. Falcone apparently didn't have the integrity or courage to tell you that he'd already live streamed the video yesterday when you asked him about it speaks volumes. Number two, the fact that not one, but two of the state's witnesses were now watching the live stream speaks volumes. Number three, that partisan witnesses who clearly have hard feelings for Mr. McDonald have now produced additional evidence to rebut my opening statements and assisted the state. I'm going to move for mistrial with prejudice as a result of the state's misconduct. They should have instructed these witnesses not to watch on live feed.
I don't think that anyone knew that there was a live feed happening. And your request regarding them not publishing it or in the exclusionary rule didn't happen until after opening statements were made. So that is a challenge. All right, I do need to take this under consideration. Of course, our poor jury is already here. This is going to take a minute. So please advise the jury that something came up that needs to be resolved before we bring them in. Let them know if they want to get a coffee, they're free to do that, and to be back here in 45 minutes. All right?
No problem.
And please give them my apologies.
Hi, Walter. I missed you yesterday in OJ.
All right, is there another issue that came up besides?
No.
Okay.
They kind of sandwich each other.
Yeah, they do.
So, yeah, it's one issue.
All right.
And Ted, I know you're contemplating this and you're asking for 45 minutes. If it helps solidify the timeline for whatever record, if you're debating whether this is a mistrial or not, I believe Mr. DeCiro is here. He could testify about what he did in fact see on live streaming and why he sent this. And if you want, I'm just.
Yeah, let me consider this for a few minutes. I'll be back here in about 15 to 20 minutes, so everyone can be at ease until that time.
Thank you.
Thank you.
There's a recess.
We're back on.
You heard her, especially you, Lori. The judge said everybody needs to be at ease. So ease down, people. Let's go.
Record is C18333684-1. Before the break, there was a motion for mistrial based on information the parties learned. One, that two of the state witnesses had watched all or part of opening statements that were live streamed yesterday afternoon. And two, the emails that were turned over to the state or provided to the state yesterday evening. The emails are dated Monday, October 28, 2019. Two were at 10:27 p.m. and one is at 10:30 p.m. The emails are from an email address, michaelmcdonaldwork@gmail.com to a mark.theserial@gmail.com. The state has advised that this was the first they received these links. They show an email inviting Mark DeCiro to edit 3 documents, one being a divorce chronologue, the second being police entitled appeals, and the third being court videos. I'm going to talk about the opening statements first. I'm going to deny the motion for mistrial based on the argument that there was issues with the witnesses watching opening statements. I am troubled and concerned that the court was not informed that the videos were live streamed, but 2 things. First off, there was no motion for an exclusionary rule to be invoked until after opening statements, and even if that were the case, there was no witness testifying. Therefore, there's no violation of the exclusionary rule. So there was no prejudice to either side based on reviewing the opening statements. The second question is what happens with this new discovery that was provided to the state last night at 10:30, or around 10:30. I am going to grant the motion for mistrial, however, I'm going to grant it without prejudice because of the late disclosure of these emails. During the opening statement, Mr. Mueller laid out his defense, and his defense was that this was a hacking job on behalf of Mr. DeCiro. These emails directly undermine that defense, and it would be prejudicial to Mr. McDonald to have to recover from a committed defense that was placed before the jury during opening statements yesterday. So I'm going to grant the motion for mistrial again without prejudice, and we do need to reset this for trial.
Your Honor?
Do either want to make a record as to either of my rulings?
Your Honor, at this point, Mr. McDonald has asked me to withdraw our motion from this trial if he wishes to proceed to trial. If we ask simply that these late disclosed emails are excluded from evidence, Mr. McDonald's been in custody now for an extended period of time. He is not a criminal or member of the criminal class.
Is he currently in custody on a separate case?
He's currently pending sentencing on Wednesday, I think it was Wednesday or Thursday. This recommendation from PSI, or from the PSI is for probation. He was out of custody in this case, but the bondsman saw a chance to surrender him.
Isn't mistrial good for him? Like, that was a win for him because he said they hacked into it. They told the jury they hacked into it, and now they have proof that nobody hacked into it. Dude, take the mistrial. Please, start over. You get a redo on this. No, please. He just... What's the worst decision I can make at this possible moment? Yeah, no mistrial. Okay, I'll go with that one.
So I would prefer to go forward with simply limiting, Mr. McDonald would prefer to go forward with simply limiting the state's ability to use this. Obviously, now that we know it exists, I can't imply that it doesn't. I understand the rule. Having said that, Mr. McDonald is anxious to get this behind him, and we've got only 500 days of credit on this case.
All right, we'll hear from the state on that request.
And Your Honor, my request is if we're going forward, that we be allowed to use this information. It's not particularly complicated. This isn't like a case in which someone gets a last-minute DMA report or something like that. Additionally, the defendant is in custody on another case, which is set for sentencing tomorrow morning. And I do not believe he has 500 days credit in this case.
Well, was he, I was mentioned he was out of custody on this case initially, am I correct in this?
Yes.
So he was remanded in the case before Judge Israel?
Yes.
All right, has he been remanded in this case?
The bondsman surrendered him once he got remanded. So if he had not gotten remanded in the other case, he would have been out of custody of this one.
And the bond surrender happened a few days ago, I believe on the 23rd. So he has less than a week
Okay.
in this case.
All right, so let me understand the defendant's request. You are asking to withdraw the motion for a mistrial and to proceed. You understand that you cannot, well, let's say this. If you argue this was a hacking job, then these emails come in. You understand that?
Yes, Judge, there's the details. Mr. DeCiro has never given a full or satisfactory explanation of what he exactly did. So that he got permission to get into Google Drive apparently is at least personally established that his actions exceed for the purpose of the granted permission, in which case he's still violating the statute. So and unfortunately this is criminal law, so I can't take a deposition. If you didn't want to talk to investigators, so I have to deliver what answers he goes to some stand.
All right, and you're making this request as a affirmative trial strategy.
Yes, sir.
All right. Mr. McDonald, how are you?
Ms. Monroe. Raise your right hand. Do you solemnly swear the testimony you're about to give in this action shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Please state your name for the record.
Michael John.
Morning again. I want to
Hi,
confirm
Sudo.
that you agree with your attorney's request to withdraw the motion for mistrial.
Yes, Judge, I just want to get this behind me and put it off, and I believe that this case has no merit, and I'd like to proceed and get this over with, please.
All right, and do you understand that by withdrawing the motion for a mistrial, that that's a trial strategy that would not be a basis necessarily for an appeal later? Should you get convicted, there's now an affirmative record that you are actively making this decision and want to pursue the trial for
I
today.
understand that, Judge.
All right. And do you need any additional time to talk to your attorney about your decision to make this motion to withdraw the motion from this trial?
No, Judge, I'd like to proceed with the trial, and I would like to confer with my attorney and have a few minutes to discuss some strategies and to ask questions of the witnesses.
That's a reasonable request, and I will grant that request. All right, thank you. You can be seated. Thank you very much. The other party need to lay anything else in terms of the record?
I think we understand the parameters of what they're agreeing to here.
All right, well, let me ask the state this question. Do either of you plan on putting these emails in your case sheet?
If they are brought into controversy by the defense, then, not in the case appeal, I suppose, it might be on a redirect situation.
All right. Because they were disclosed today, and I understand they were emailed to you at 10:27 last night, the order of the court, you can use these should the door be open. There's a question for you about how to process the recording and access to the Google Drive. All right, so therefore I will grant the motion to withdraw the motion for this trial. I believe the jury is outside.
Yes,
Copy that?
Your Honor.
Okay. I want to give Mr. McDonald a few minutes to talk to his attorney. I think that's reasonable. I'm going to ask the state to step outside. I'm going to step
few
out,
minutes?
give them time to talk. We will start at, is 20 minutes enough time? Maybe more time than that. Yes? Mr. Miller?
That'd be fine, I think start over there.
We'll start at
We'll go to
11.
this board break room back there.
That'd be great. We'll start at 11:30. All right? The court will be in recess until that time.
No mistrial. They're going forward with the lies.
Record and state, Michael McDonald.
Good morning, Your Honor. Craig Miller, Baptist McDonald. Thank you for granting this to speak.
Yes.
Mr. McDonald told me several things in discussing the recently disclosed email that are going to really make it impossible for me to effectively represent him with this magnitude of surprise. It also indicates to me, now that I spoke with Mr. McDonald, got an explanation, the existence of evidence that will conclusively prove his innocence, and will certainly cut out the need for a trial in the first place. Over Mr. McDonald's objection, I'm going to remove the motion for mistrial. I do not believe that the justice is served by forcing the issue at this point. There's witnesses in California who can prove that he was out of town for some of these conversations, and I simply do not go forward knowing what I now know. And it is over Mr. McDonald's explicit objection, and I agree that he can make a record too, but I cannot be effective knowing what I now know.
Understood. 1 second, Mr. McDonald, I'm going to talk to you. State if you have any response.
No response, obviously, on Mr. McDonald.
Thank you. All right, Mr. McDonald. I understand this is over your objection. Is that correct?
Yes, Judge, I would, like I said, I would like to file a motion to dismiss with evidence attached to it that proves that that these charges are completely frivolous. And if there's a way to do that, I'd like to do that. And if not, then I would like to proceed with trial and just be done with this. Judge, I just want to get all this over with and move on, please.
All right, so and I appreciate that. I know you are in a difficult situation, but your attorney is an officer of the court. He has ethical obligations and professional responsibility obligations, and he's advising me that there's new evidence that he believes that he could obtain or is relevant directly to your defense, and therefore he would not be doing his duty as your attorney to not investigate that further. It would be a different situation if this evidence hadn't come to light and we were moving forward. But now he has his information and has his evidence, and that puts him in a difficult situation.
Judge, the evidence that he doesn't have the evidence is currently incarcerated, Mike.
Okay, so you are incarcerated. I don't want you to talk trial strategy or potential defense strategy because the state is still present, and it's in your best interest not to talk about that. I am going to grant the motion for a mistrial. Again, I'm going to grant it on the basis of the fact that opening statements were presented and there was a defense strategy laid out for the jury, and the evidence that was provided this morning, that was provided to the state late last night, changed that potential defense, and I think that is unfairly prejudicial to the defendant. I understand secondarily that now there's potentially new evidence that needs to be gathered and provided to the state. And therefore, that just further creates more prejudice for the defendant. Again, I understand this is over the defendant's objection, but as an officer of the court, I am relying on Mistrial recommendations as his attorney, and I do think it's in the best interest to grant the mistrial at this time. It is without prejudice, so let's go ahead and get a new trial and calendar call date. Let's have it as soon as possible. I want to respect the surveillance position regarding where we are.
And respectfully, Judge, because it's been set for the other case tomorrow, there might bear some timing issues on when you want to have a trial. Maybe gotta check next week, when you free?
No, are you okay with that, Mr. Newman?
Actually, I was going to propose, you have a criminal calendar later this week.
I do tomorrow is my criminal calendar. And
Is
then
it possible we can add this on, and I will draft a written motion for no cognizance and have it on file this afternoon?
Well, I want to make sure the state has an opportunity to respond. What we could do is set it for status tomorrow afternoon.
Thank you.
Ever
Does that work
since
for both
last
parties?
year.
Well, you were planning on being here, so I imagine you're available. Okay, well, why don't we do a special setting tomorrow afternoon, we'll know what happened in the other case. If you file that motion for release, I would appreciate if you get something written response filed. If not, I'll accept oral argument because it will be short notice.
Thank you.
Tomorrow, let's do,
Well, first there was a mistrial, and then there wasn't a mistrial, and then there was a mistrial, and then there was a conversation, and then there's a mistrial.
and setting that date. All right, anything further on behalf of the state or the defense?
No, yeah.
All right, well, let me go ahead and bring the jury back in, and we need to talk to them about what happened.
All rise for the jury.
Mel nailed it.
Please be seated, come to order.
Good morning, everyone, please be seated. Back to record in case C-18-333-684-20, the parties stipulate to the presence of the jury.
Yes, Your Honor.
Yes, Judge.
All right. All right, good morning, ladies
Linus, if you need an alibi, I'm your alibi.
and gentlemen. I'm sorry that you were waiting. I know we had said we were going to start at 10:30 today. Some unexpected legal issues came up that we needed to resolve before we could continue here today. As it turned out, we were unable to resolve those legal issues, and therefore I have declared a mistrial in this case, a mistrial without prejudice. So what that means is you waited an hour to be told you could now go home. And so I apologize for that. I would like to sincerely thank you for your participation. I know yesterday was a long day, and I'm sorry that you didn't get to complete your jury service through to verdict, but there are things like this that happen more often than I would like, but they do happen every now and then. And so thank you very, very much for your participation. I'm going to ask that you step up into, we have a jury room back here. I'll be right there. I want to thank you personally before I let you go. And with that, this case is over. And thank you again.
All right, so jury.
Let the record reflect that the jury has left the courtroom. My thanks to everybody this morning, and we will see you tomorrow afternoon at 1:30.
All right, thank you.
Thank you.
Court is in recess.
I'm just waiting until it hits the end and it switches to the next video so tomorrow we don't have no confusion. Okay, we'll have confusion tomorrow because that's just, you know, how life works, but that's fine. Alright, guys, thank you so much for coming out to this day. It was weird. I didn't quite understand what was going on half the time. Alright, 70% of the time. The other 70% I was walking to get my coffee and my whole stream broke. But that's, you know, that sucks actually. It didn't have to happen. I did nothing wrong. Yes, go take a nap. I am going to start O.J. Simpson trial. He was a famous football player. You don't know. Alright. Thank you so much for coming out. Happy Valentine's Day. You are all my Valentine, whether you like it or not. I'm not even asking consent. I'll ask forgiveness, not permission on this one. I hope you guys have a great day and eat some chocolate. Or get a flower. I shall talk to you all again very soon. Bye guys. Thank you.
Got these life that goes digital dreams through the screen, her blue eyes gleam. Wicked humor, sharp as a knife. Her stream sparks electric light. Late night when the world sleeps, she's the friend that always keeps. Giggles roll like thunder loud. She stands out in any crowd. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a way, there's no alarm. Freedom tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle, she lights the way. Her eyes hear a sky so blue. In her jokes, there's a truth so true. With each string, she brings the light. Turns dark days into bright. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a way, there's no alarm. Streaming tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle, she lights the way. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a way, there's no